This JT rule of law covers the agency concept of when a principal or an employer is responsible for the torts committed by their employees or their agents. As a general rule, anyone who commits a tort is responsible for their own actions. So if you are driving a vehicle and you carelessly go through a red light and T-bone and crash into a minivan and kill a family of 4, you are responsible for the damages caused by that traffic accident. However, under agency law, if at the time of the accident you are actually engaged in the business of your employer, if you were in the course and scope of your employment at the time of the crash, your employer or your principal will also be responsible for the damages you caused by your carelessness. It is called the concept of respondent superior, which is a rule that states an employer is liable for the torts of its employees or agents while they're acting within the scope of the employer's authority. So how do you determine if an agent or employee was acting within the course and scope of employment at the time an accident was committed? When faced with this situation, lawyers and judges will look at the totality of the circumstances of the tort in order to determine whether the employee/agent was within the course and scope at the time of the accident, therefore making the employer principal responsible. So a couple of the questions that the court will look into was, first, was the act specifically requested or authorized by the employer or the principal? Were you told to go from location A to location B? 2, was it the kind of act that the agent was employed to perform? Were you doing your job at the time of the tort? Number 3, did the act occur substantially within the time period of employment authorized by the principal? Or was this do you work 9 to 5 and did this happen at midnight? Number 4, did the act occur substantially within the location of employment authorized by the employer? And finally, and generally, was the agent advancing the principal's purpose when the act occurred? Were you doing something that was going to benefit your employer or your principal when the tort was occurred? And if, in looking at the situation when your tort was performed, when you went through that red light and killed that family of 4, if it was determined that you were acting within your course and scope of employment, you will be responsible for that accident and your employer will be responsible for that accident. So what if, when you are looking at the totality of the circumstances, it is not clear whether you were within the course and scope of employment? What if you veered from your specific job duties, and it was during that veering from your duties when you went through the red light, crashed into the minivan, and killed a family of 4? Were you in the course and scope of your employment at the time of the accident? Clearly, your employer is going to want to say, no, you were not in the course and scope. Therefore, you're totally responsible for the accident yourself, and the employer has no liability. And of course, the injured person is going to want to say, yes, you were in the course and scope of your employment, because your employer is the one that has the bigger insurance policy and the more money. So they want to be able to put liability on the deeper pocket. So when determining when you're on a veering, when the accident occurs, or the tort occurs, the court's going to look to whether you are on a detour or if you are on a frolic. If you are on a mere detour, the court's going to conclude that you were within the course and scope of employment. A detour is considered within the course and scope of employment. However, if the court determines that you were on a frolic when the accident occurred, you are no longer advancing your employer or your principal's interest, and you are not going to be considered within the course and scope. So detour within course and scope, frolic not within course and scope. So to look at an example, let's say you're a delivery driver and you have a warehouse where you start your day. You show up at work, you get a delivery van, you fill the van, and then your job is to drive and make a number of deliveries over the course of the workday. So you pick up your van and you drive your delivery route. You drive from the warehouse to delivery point 1, and while on the way you cause a motor vehicle accident. You go through a red light, you T-bone a minivan, and you kill a family of 4. Since you were driving from point A to point B, you are within the course and scope of your employment. Therefore, your employer is responsible under the concept of respondeat superior. So let's say later in the day you finish your second delivery and you veer off the route and you go a half a mile so you can have lunch at McDonald's. So you have lunch, you head back to the route so you can go to delivery number 3, and you cause a motor vehicle accident, killing a family of 4. Are you on a detour or a frolic? So in this situation, the court's going to determine pulling off your route, veering to go have lunch or go to do your banking, etc. Those are expected activities. They're minor little veers. So that's going to be considered a detour, and the court will deem you to be within the course and scope of your employment. So let's say that instead of just veering off for lunch, you make it to delivery 5, make your delivery, and you still have some time to kill. So you decide that you are going to drive from Atlanta to Athens to visit your girlfriend. It's an hour drive out of your way. On your way back, you go through a red light, you commit a tort, you kill a family of 4, and you are sued and your employer is sued. And your employer at this situation is going to say, wait a minute, they were not on a mere detour when this accident happened. They were on a frolic. Something so far out of the ordinary, something that wasn't advancing the employer's interest at the time. And if the court agrees that it was a frolic, the employer will not be responsible under respondeat superior. You are no longer in the course and scope of business, and you will be 100% responsible for the accident.